Hello everybody, welcome to iExamB. Embrace the iExamB learning experience. In our legal maxim series, now we have come to part 16. So let's start with the first important maxim today, that is public juris. This means of public right. This also means belonging to the public. It signifies a thing or a right that is open and exercisable by all persons. In general, it designates things that belong to an entire community and not to any private party. For example, water in the sea. The next maxim is par delictum. This means equal fault. It indicates that the parties involved in an action are equally culpable for the wrong committed. In simple terms, when the parties to a legal controversy are in par delictum, neither can they obtain affirmative relief from the court since both are at equal fault or of equal guilt. They will remain in the same position they were in until the action begins. The next maxim is pari passu. This means on an equal footing. When several lenders jointly finance the same asset, this is referred to as co-lending. A co-lending solution requires that the lenders enter into a pari passu or asymmetrical agreement that establishes how sums will be allocated between each creditor in case of realization. The next maxim is per curiam. This means in the opinion of the court. Per curiam is a judicial opinion by a court with multiple judges without citing any single judge as the author. A per curiam decision is a court opinion issued in the name of the court rather than the specific judges. Most decisions on the merits by the court take the form of one or more opinions written and signed by individual justices. Often, other justices will join these opinions. Even when these signed opinions are unanimous, they are not per curiam as the judges' names who wrote and joined in the opinion still appear. On the contrary, per curiam decisions are typically short and resolve cases through summaries and without hearing oral arguments. The per curiam opinions will typically address issues the court views as relatively non-controversial. The next legal maxim is per menas. This means by the means of menaces or threats. When a person is forced to enter into a contract by threats or menaces, it can be called per menas. When a person fears death or any mayhem on not acting according to the threat, the person may act as instructed. Nevertheless, the acts performed in compulsion may be changed by the person afterwards. The code only required that the individual was compelled to act by threat and that the threat was not one that could have been resolved by a strong and fair man's mind and will. The next legal maxim is pro rata. This means in proportion. Pro rata describes proportionate allocation. It's a process in which an allocated asset will be distributed in equal proportions. An amount is assigned to one person according to their share of the whole if something is distributed to several people on a pro rata basis. The next legal maxim is pro tempore. This means for the time being. Something that is pro tempore is temporary or provisional. In the legal field, it is often used to refer to judges who are filling a temporary vacancy for another judge. The term can also be applied to attorneys who have been appointed to serve as a substitute judge for an absent judge who regularly sits on the bench. So these were all the legal maxims in this series. I hope you are making the best use of this series. Keep on revising the legal maxims. If you want any form of practice material with phase 1 exam coming soon, you need to check out where you are. What is your preparation level? You want to revise and practice, attempt mock tests, you can check out our quick revision course. In this course, there are 15 mock tests for phase 1 paper 1 and 15 for phase 1 paper 2. This will give you a good practice and revision. Enroll with iExamB and make your preparation 50% faster. Thank you so much for watching this video. Subscribe to our channel. Stay tuned.